Be permitted to mention 134 matter, my lord. Both of which of 2022 and 2019, my lord. The question involved is, my lord, the unilaterally appointed arbitrator has passed an award against us, my lord, and refused our claim, my lord. My lord, we are praying if the matter can be taken up, my lord. Section 34. Grateful.
State matter, item number 1.
For the judgment.
Lordship, I appear on behalf of the award holder. My instructions are to withdraw this matter.
Learned counsel for the petition seeks to withdraw the present petition with liberty to file appropriate proceedings.
Lordship.
And petition shall be withdrawn with liberty as well.
Grateful, Lordship.
Item number 2.
I have received instruction from client to withdraw this application. Learned counsel for the petition seeks to same order. In this is section 9 application, we have with liberty to file appropriate proceedings. Because in the jurisdiction involved, Delhi High Court, that's both the matters, 2 and 3.
Please, sir.
Item number 4.
Your Lordship, I appear on behalf of the petitioner. On the last occasion, Your Lordship had asked to serve the copy on the other side once again. So we have duly complied with the same.
Served?
Yes, Your Lordship. It has been delivered.
Yes, tell me.
Your Lordship, this is an 29 application. This will be the third extension. Previously,
Appearing before the arbitrator?
yes, they are appearing before the arbitral tribunal. Up until the last minutes also, they have appeared.
When was the where is the last extension page?
The
38?
last 29A order is on page 38.
Take down. The petition has preferred the present petition under section 29A of the arbitration conciliation, seeking extension of the mandate of the arbitral tribunal. What is the stage of the procedure?
The claimant is currently giving the counter arguments to the respondent's arguments. Thereafter, the respondent will be giving their counter arguments.
The arbitral proceedings and public. Learned counsel for the petition submits that this court on 3 previous occasions by order dated you said 3 extensions have been given, right?
Sorry, Your Lordship.
How many extensions have been given earlier?
The first extension was by consent of the parties for 6 months. Thereafter, the 29A order passed by this honorable court.
And earlier, by order dated 9 January 2026, had extended the mandate of the arbitral tribunal for a period of 6 months. Now the mandate has expired on 8/7/2020. Matter is at the stage full stop. The matter is at the stage of respondent's evidence. On consideration of the materials placed on the court, this court is satisfied that no delay in the conduct of the arbitral proceeding is attributable to the mandate arbitral tribunal, having regard to the advanced stage of the arbitral proceeding and in the interest of justice. The mandate of the arbitral tribunal is extended further for a period of 8 months from today. The arbitral tribunal is requested to conclude the arbitral extended time period proceeding and publish the award within the extended time period with the aforesaid direction. The sole arbitrator, right?
Sole arbitrator.
Affidavit service taken on record, none appears, despite service, none appears. This one.
Next.
5. Please, my lords, with your lordship's kind permission, my lords, I appeal for the petitioners, my lords. My lords, this is the third extension we've applied for. The last extension was dated 14/7/2025 on page number 180, my lords. We are today at the stage of the respondent's evidence being concluded. My evidence is already completed, my lords. I'm requesting for an extension. This is arising out of, my lords, certain technical master service agreements. And due to the my lords, insolvency proceedings of the petitioner erstwhile, my lords, there is some my lords, inadvertent delay that has taken place, my lords.
I'm not opposing you. I had raised an objection regarding their locus standi before the arbitrator also. If my lord is only pleased to observe that this is without prejudice to whatever I have to say before the
That they have
arbitrator.
lost in that filed section 16 laws there.
But ultimately this should not
I
be taken.
am not getting.
Yes.
Yes,
My lord,
my lords, I must point out with just one line, my lords, your lordships are extremely grateful to not record this, but this is very unfortunate way they are trying to get all of these recorded in, my lords, these administrative applications, which should not be the, my lords, the process. That's all I submit, my lords. I'm in the lordship's act.
they filed a section.
Arbitrator or
Sole
Sole
arbitrator.
arbitrator, my lords. Mr. Jayanta Mitra, senior advocate, is the sole arbitrator, my lords.
all right. Take that.
Mandate is still, my lord, 14th of July 2026.
This court by order dated 21/1/2021 appointed the sole arbitrator to adjudicate the dispute between the parties. The pleadings were completed on 12/3/2022. Full stop. With the consent of the party, the mandate was extended till 12/9/2023. This court by order dated 8/3/2024 and 14/7/2025 extended the mandate by 4 months and 1 year respectively.
5/6 na শুধু 5.
In the meanwhile, through auction process conducted by the official liquidator, the petitioner company was sold off and the new management has taken over. Full stop. The learned counsel for the petitioner states that the matter is at the stage of respondent's evidence.
Yes, my lord.
Recording of
Cross examination is to start.
recording of respondent.
Going.
Responding sentence.
Learned counsel for the respondent does not have any objection to the present application. Upon consideration of the materials placed on record, this court is satisfied that no delay in the conduct of the arbitral proceeding is attributable and its own arbitrator. Keeping in mind the advanced stage of the arbitral proceedings and in the interest of justice, the mandate is extended further for a
My
period
lord,
of
my lord, I would request for a period of 1 year, my lord, we'll complete within that. But my lord, 1 year, so that we don't have to come
1 year
back.
from
Grateful.
Extremely grateful, my lords.
Grateful.
arbitral travel.
And 6.
Your Lordship, I am appearing on behalf of the petitioner in this matter, Your Lordship. Here's my affidavit of service, Your Lordship. I have served the petition upon the respondent. Your Lordship, this is the third extension. First extension was mutually agreed between the parties. The second extension, Your Lordship, at page 70, Annexure D. By an order dated 7 November 2025, Your Lordship, please to extend the mandate of the arbitral reference for a period of 6 months. This is in the stage of the final hearing, Your Lordship. On the second page, at page 71, presently at stage of the final arguments, Your Lordship, already Your Lordship has been stated. Our submission has been completed. The respondent, they replied. Against the reply of the respondent, I have to rejoinder there too. We have submitted 2 sittings. We have already made the submission. Only maximum 2 sittings were required to make submission. In the meantime, Your Lordship, I annexed the communication made by the learned arbitrator due to personal difficulty of the learned arbitrator, unable to held the several sittings, Your Lordship. From page, Your Lordship, page 82 to 87 till 89, Your Lordship. So in the meantime, the issue has been caught up that mandate has been expired, Your Lordship. So, Your Lordship, I am preferring this application. Also, Your Lordship, I have to mention that there is also a delay in the preferring application, Your Lordship. The reason for the delay is clearly stated, Your Lordship, at paragraph at paragraph 24, 25, Your Lordship.
Where's the other side? You served them?
Your Lordship, I have served upon the learned advocate of the respondent.
Affidavit service taken on record. Required service not The court-wide order dated 17 January 2023 appointed a sole arbitrator to adjudicate the dispute between the parties. The on previous, how many the pleadings were completed on 7/5/2024. With the consent of the parties, the mandate of the tribunal was extended for a period of 6 months. Full stop. This court, by order dated 17th November 2025, extended the mandate of the arbitral tribunal for a period of 6 months. Full stop. Learned counsel for the petitioner submits that the matter is at the stage of conclusion of final arguments. Upon consideration of the submissions and material placed on record, this court is satisfied that there is no undue. How much time?
Your Lordship, 3 months.
3 months.
3 months.
For a period of 3 months.
Much obliged, Your Lordship.
Number 7.
Look, this is my application under 29A for extension. This is, my lord, the second section 29A application. Here, my lord, the notice invoking arbitration was 12th of July 2023. Well, that's, well, in fact, without troubling my lord to the page, I can well, possibly by consent, both parties will agree that 1 year period will be required. The reason being, my lord, it's a consolidated reference arising out of 24 purchase orders relating to 8 Indian Navy ships.
Where's the last extension?
The last extension order, my lord, is of order dated 5th August 2025, page 118. Final arguments are going on. It's at the stage of reply by the respondent.
Proceedings are at the stage of
Final hearing, reply of the respondent. After this, I'll give my rejoinder.
9A. This court, by order dated 13/9/2023, 13/9/2023, appointed the is a sole arbitrator or a
Sole arbitrator.
sole arbitrator to adjudicate the dispute between the parties. The pleadings were completed on 16/2/2024. With the consent of the parties, the mandate was extended for a period of 6 months. Full stop. Thereafter, this court, by order dated 14, this is 5th August. Right?
5th August 2025.
Only one order or there are more orders?
One order extending that is
August
expiring in August 2026.
It's the mandate of the arbitral tribunal for a period of
1 year, it was period extended for 1 year, which is expiring in August.
1 year. Full stop. Learned counsel for the respondent states that he has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Learned counsel for the petitioner states that the matter is at the stage of
Final hearing.
final hearing. Full stop. Upon consideration of the materials placed on record, this court is satisfied that no delay is attributable to the learned sole arbitrator in conducting the arbitral proceedings. Full stop. Keeping in mind the advanced stage of the arbitral proceedings and in the interest of justice, the mandate is extended further for
1 year.
1 year from today.
Great. Well, the affidavit of service may be taken out. Grateful, my lord, deeply.
My lord,
Yes.
so, my lord, appearing on behalf of the respondent, and this is a case of arbitration. Our wakalatnama shall be filed within few minutes. She's seeking time, your lordship.
Item number 8.
My application, my lord. This is the second extension. My lord has granted the first extension on 7th of
Which matter are you
November, my lord,
appearing,
2025.
Madam, which matter are you appearing in?
Item number 4, sir. Lordship view, item number 4.
Do you know which matter is going on right now?
It's item number 8.
Then
This is the second extension, my lord. First extension was granted by my lord on 7th of November.
other side.
I have served, my lord. For the last 4 sittings also, my lord, the respondents are not appearing, my lord. And my lord, everything is completed. Only the order is reserved, my lord. The award is reserved, my lord. My lord will get that from the last minutes. That is appearing at page 151, my lord.
Is the service report?
Service.
How have you served?
Served through email, my lord, to the advocate on record of the, my lord, the respondent, my lord.
Why only email?
On the last occasion when I went to serve the hard copies, they refused it and said that
You
you,
should have sent it to post.
my lord, kindly consider that on for last 4 sittings, my lord, they are not appearing
They are not appearing, but
before the arbitrator, my lord, and the arguments are closed, my lord. Only the award is to be passed, my lord. And I'm humbly praying for a 2 weeks extension, my lord. In that period, my lord, the arbitrator shall pass the award, my lord.
Same 29A4. Where is the last extension?
Last extension is at page, my lord, 111, annexure P, my lord. Order dated November 7, 2025. It was extended for the period of 8 months.
Applicant service taken on record, despite service. This Senate Counsel for the petitioner states that the mandate of the arbitral tribunal has been extended how many times?
Extended for a period of 8 months, my lord, which to terminated on July 6, 2026, my lord.
On how many occasions has it been extended?
What has happened, my lord? Initially, one arbitrator was appointed. Thereafter, my lord, the erstwhile arbitrator was substituted. That is by an order dated September 24, 2024, my lord.
Yes.
Then, my lord, the present arbitrator was appointed, and the mandate of the present arbitrator was first extended by an order dated November 7, 2025. That is at page 111.
Yes.
And this is the second application, my lord, for extension, my lord. And my lord will get that only the award is reserved. That is from the last minutes, my lord. That is appearing at page 11151, my lord.
Extended by this court by order dated 7/11/2025 for a period of 8 months till 6/7/2026. He further states that the matter is listed for pronouncement of the award. Full stop. Upon consideration of the material placed on record, this court is satisfied that no delay in the conduct of the arbitral proceeding is attributable to the learned sovereign. Having regard to the advanced state of the arbitral proceedings and the interest of the mandate of the arbitral tribunal is extended further for a period of 3 months.
For 2 weeks, for abundant caution, my lord, for 1 month.
For 1 month for publication of the award. 1 month from today for publication of the award. The learned sole arbitrator is requested to publish the award within the extended time period with the aforesaid direction.
Grateful to your lordship.
No, 9.
Your Lordship, in serial number 9, I'm for the petitioner. We had served the 29A, both hard copies and scanned copies, and thereafter they have issued this email to us conveying their no objection. May I just place on record the brief facts? This is the affidavit of service and notice of motion.
How many respondents?
Only one respondent. This is the second 29A petition. The first
one order.
that is on page number 16. It's 21st July 2025. The arbitration is currently at the stage of final hearing. The claimant has already concluded.
This court might order it. Affidavit of service taken on record. Despite affidavit and notice of motion. Taken on record despite service none appears for the respondent, though learned counsel for the petitioner has handed over a copy of an email received from the respondent wherein the respondent had given his no objection to the grant of extension of the mandate of the arbitral tribunal. Full stop. The same is taken on record. Full stop. Learned counsel for the petitioner submits that this court, while order dated 17/3/2023, had appointed a sole arbitrator to adjudicate the dispute
Yes,
with the parties. Full stop. The pleadings were completed and the parties by mutual consent extended the mandate by 6 months. Full stop. This court, while order dated, this is 21/7, right? 21/7/2025, extended the mandate for a period of 1 year.
1 year.
Full stop. The matter is at the stage of final arguments. Upon consideration of the material placed on record, extended for 1 year.
I'm praying for 1 year.
Why? It's in the final argument.
That's my prayer. Your Lordship may deem fit.
6 months. 6 months. 6 months. Prayer should be reasonable.
Grateful.
6 months.
And not 10.
Item number 10, my lord, I am appearing for the petitioner claimant. This is my application for extension of the mandate. This is my second 29A application, lordship. The first extension under section 29A is appearing at page 91, lordship.
Any objection, madam?
The claimant has concluded its submission, lordship. The respondent has to commence and thereafter, if any, reply by the claimant and then.
29. The court, while order dated 12/4/2023, appointed the sole arbitrator to adjudicate the dispute between the parties. The pleadings were completed on 1/12/2023, 21/5/2023. And the parties by mutual consent extended the mandate by 6 months till 19/5/2025. This court, while order dated 18th June 2025, extended the mandate for a period of 1 year. The matter, both the parties state that the matter is at the stage of final arguments. Full stop. Learned counsel for the respondent states that she has no objection to the extension of the mandate of the arbitral tribunal. Full stop. Upon consideration of the material placed on record, no delay attributable to the learned sole arbitrator. Extended for?
Extended for 1 year from the date of communication.
How much you want now?
8 months, lordship. 8. The respondent has to commence their arguments and thereafter reply and then the publishing of the award, lordship. It's a 3-member yes, it's a 3-member arbitral tribunal, lordship.
So I asked you. Arbitral tribunal. Appointed the arbitral tribunal. Eight months you want? 6 months or 8 months?
8 months. Since it's a 3-member tribunal, there is a
8 months.
grateful. Affidavit of service may be kept on.
Motion section 11, item number 11.
My lord, my senior is in court 61. I pray for a passover.
Have it on Monday. Not today, Monday.
I wouldn't oppose, my lord, because last day I was a little under the weather. So
But they have come up with a point of limitation, my lord.
Otherwise, perhaps I am required to argue, my lord. If I can commence, if my learned friends.
Limitation will be looked into by the arbitrator.
Yes, my lord. That was our argument.
Your lordship. My contention was, my lord, section 8 application per se will not give a go-by to the section 21 notice. The disputes have commenced admittedly in the year 2018. Thereafter, the respondent had filed a suit where they had filed a section 8 application that was pending. That got disposed of on 4th of January 2025. And thereafter, the section 21 notice has been issued by the petitioner before your lordship on 26th of March 2026. 16th of March 2026 this year.
Perfectly fine. Was the difficulty then?
My lord, I have been able to lay my hands on a particular judgment, my lord, passed by the division bench of the Delhi High Court. Section 8 per se, my lord, mere pendency will not give a go-by to the obligation of the particular party to refer the disputes to arbitration in terms of Section 21.
Not a deadwood claim.
My lord, it would be a deadwood claim.
My lord, a development agreement
That
of
would be my contention,
2012,
my
my
lord.
lord.
Thereafter, whatever first
My lord, development agreement of 2012, 5 years pass by, they pay no heed to discharge their obligations.
All before the arbitrator.
They went on to file a title suit.
perhaps
My lord, may kindly pass on, if your lordship allows me, I can make the submissions. my lord.
You want to make submission? Did I stop from making submission? You only said you want to. Your senior is busy in the court. Yes, tell me. I'll be the first person to encourage you to make submissions. Yes.
I'm grateful, my lord. The development agreement of 5th August 2012. Your lordship may kindly, my lord, come to the agreement once. I would take your lordship through few clauses of the agreement. My lord, the arbitration clause is in page 27. And my lord, the no cancellation clause is in page 25. My lord, page 25, if your lordship has followed. In the event any default on part of any one party, the other party shall be entitled to sue the party in default for specific performance of this agreement and also for damages.
Where are you reading?
My lord, page 25, clause 23.
Yes.
In the event any default on the part of one party, the other party shall be entitled to sue the party in default for specific performance of this agreement and also for damages. However, if there is any delay in completion of the project, the consequences mentioned in section clause 17 shall apply. My lord, they have already invoked this clause. 5 years passed by after 2012. They pay no heed to discharge the obligations. They went on to file a title suit in order to drag us into one. The title suit's order came in January 2025, my lord. My lord, may kindly take the order once. Page 65.
The development agreement was for.
We are the owners. They are the developers, my lord. My land is still with them, my lord. And I can't use my land commercially. So there is no deadwood claim. It's a continuing cause of action. We are still facing the consequences of it.
Yes,
My lord, kindly come to page 65 once.
Yes.
Page 69, your lordship will find the operative clause of the agreement. Hence, its order, this miscase can be and same is allowed on contest without any order as to cost, and the title suit is hereby referred to arbitration since the civil court has no jurisdiction on the subject matter on the title suit. In view, miscase and title suit are both disposed. Yes.
That has been referred to arbitration. This is the disposal.
In 2018, they dragged us into the title suit, my lord. 2025, the final order came. Subsequently, we have sent our section 21 notice, my lord, and they replied to it. They rejected our nomination. My lord, I have come up with judgments. And my lord, I have come up with judgment. Na crisping na beta. (2025) 1 SCC
copy.
502, my lord.
Yes.
This is the latest judgment, my lord, I have found out.
To show what?
This considers crisping. This considers all the relevant judgments, my lord. If your lordship kindly takes para 33, my lord.
Yes.
My lord, in para 34, they consider Vidya Drolia.
Yes.
And if your lordship kindly takes para 36, next page, my lord, they have considered all the judgments, BSNL, Nortel networks.
Wanna read it?
Yes, my lord, I'll show your lordship one relevant paragraph, my lord.
Take your time.
Yes, yes.
No hurry.
But I would read your lordship para 43. They have considered all these judgments. They have considered Arif Azim. This judgment has partly overruled Arif Azim, my lord.
Yes.
And says in para 43, therefore, while determining the issue of limitation in exercise of powers under 11.6 of the Act, the referral court must only conduct a limited inquiry for the purpose of examining whether Section 11 application has been filed within the limitation period of 3 years or not. At this stage, it would not be proper for the referral court to indulge in an intricate evidentiary inquiry into the question whether the claims raised by the petitioner are time-barred. Such a determination must be left to the decision of the arbitrator, my lord. Para 43 says, after all, in a scenario where referral court is able to discern the frivolity in the litigation on the basis of bare minimum pleadings, it would be incorrect to assume or doubt that arbitral tribunal would not be able to arrive at the same interference, especially when they are equipped with the power to undertake an extensive examination of the pleadings and evidence adduced before them. Yes, now, my lord, they are saying column 51, 52, my lord, para 51, I would consider. Before that, para 46 ones, my lord, may take. Moreover, the courts are vested with the power of subsequent review, in which the awards passed by the arbitrator may be subjected to challenge by any party to the arbitration. So, my lord, they can challenge whatever disputes there are, they can challenge in 34 application, my lord. So, the courts need not go into an intricate evidentiary inquiry at this stage, my lord. Therefore, the courts may take a second look at the adjudication done by the arbitral tribunal at a later stage if considered necessary and appropriate in the circumstances, my lord. Para 51, my lord. It says, now it is well settled law that at the stage of Section 11 application, the referral court need only to examine whether the arbitration agreement exists, nothing more, nothing less. This approach upholds the intention of the parties at the time of entering into agreement to refer all disputes arising between them to arbitration. However, some parties may take undue advantage of such a limited scope of judicial intervention. Now, here the answer of the referral courts and force other parties to the agreement into participant in a time-consuming and costly arbitration process. This is especially possible in instances including but not limited to where the claimant canvasses either ex facie time-barred claims or claims which has been discharged through accord and satisfaction of the case where the implement of non-signatory to the arbitration agreement is sought. In order to balance such a limited scope of judicial interference with interest of the parties who might be constrained to participate in the arbitration such proceedings, the arbitration tribunal may direct that the costs of arbitration shall be borne by the party which the arbitral tribunal ultimately finds to have abused the process of law and caused unnecessary harassment to the other party. Well, the tribunal might take the point of limitation as a preliminary issue and borne such costs on the petitioner if it finds so. This is my submission, my lord. My lord, in the arbitration agreement, it is specified a 3-member tribunal. Because considering the low value of the claim, my lord, I have prayed for a sole arbitrator here. These are my respectful submissions, my lord.
Yes. To take the first things first, the agreement is of 2012. The notice of termination of the agreement has been issued by the petitioner on 10th of March 2018. Well, in 2018, the respondent files a suit. In that particular suit, on 18th of July 2018, the petitioner files an application under Section 8 of the Arbitration and Conciliation Act. That application was eventually disposed of by way of an order dated 4th of January 2025.
Yeah.
Now, let's subsequent thereto, the notice invoking arbitration under section 21 was issued on 16th of March 2020. So, the March 2026. So, two dates are very important. One is 10th of March 2018, when the agreement was terminated. Second is 16th of March 2016, when the notice under section 21 was issued. During the interregnum, there was a section 8 application pending. Now, the issue is whether it's an admitted position in the event, if there would not have been the suit filed, the section 8 applications pending, then obviously, it would be expressly barred by law limitation. Now, in the event, my learned friend's contention is that it is due to the pendency of the section 8 application that this time is to be excluded by operation of section 14 of the Limitation Act. First, I would humbly request that your lordship may be pleased to take up section 8 of the Arbitration and Conciliation Act once. I would primarily rely on subsection 3.
You're wasting my time.
Then I wouldn't take your lordship further. I'll directly come to the judgment. Because one, there has been no pleading whatsoever. And your lordship may take it down, may record it in the order as well, that the possession of the subject land is not with the respondent. It is with the petitioner. There's not a single pleading to that effect that the subject land is with the respondent. And if your lordship feels that I'm wasting your lordship's time, then I'll directly come to the judgment.
Hey, judgment.
Because this is the only judgment which I've been able to lay my hands on apropos the operation of section 8 in respect of section 14. The issue was raised before the division bench of the Honorable Delhi High Court. I'll directly place the first paragraph itself. The appellant has filed the present appeal under section 37(1)(c), the arbitration conciliation, impugning an order dated such and such rendered by the learned commercial court. By virtue of the impugned order, the learned commercial court rejected the appellant's application preferred under section 34, impugning the award passed by the, in terms of the impugned, perhaps, I'm so sorry, the last sentence would be important. In terms of the impugned award, the appellant's contention that the counterclaim preferred by the respondent was barred by limitation was rejected. The arbitral tribunal had accepted that the respondent had not issued any notice under section 21 of the Arbitration and Conciliation Act. Therefore, the period of limitation would run from the date of cause of action till the date of filing of the counterclaim. However, the arbitral tribunal found that the respondent was entitled to the benefit of section 14 of the Limitation Act 1963, as it had filed an application under section 8 of the Arbitration and Conciliation Act in the suit preferred by the appellant. The arbitral tribunal found that the time spent by the respondent in pursuing its application under section 8 of the Arbitration and Conciliation Act 1996 was required to be excluded for considering whether its counterclaim was preferred within the period of limitation. 3. The learned commercial court found no fault with the view of the arbitral tribunal that the respondent was entitled to the benefit of section 14 of the Limitation Act, and consequently the counterclaim was found to be within the period of limitation. The learned commercial court did not accept the view of the arbitral tribunal that the respondent had not issued a notice under section 21 of the Arbitration Conciliation Act. It had held that the legal notices dated such and such issued by the respondent, which were referred to in the application under section 8 of the Arbitration Conciliation Act, constituted notices invoking arbitration as contemplated under section 21. The learned commercial court held that in the aforesaid view, the period of limitation would end with the respondent filing the application under Section 8 of the Arbitration and Conciliation Act. Thus, the counterclaim was filed within the period of limitation for this reason as well. Two questions arise for consideration of this court. First, whether the time consumed by the respondent in pursuing its application under Section 8 of the Arbitration and Conciliation Act is required to be excluded for computing the period of limitation by virtue of Section 14 of the Limitation Act. And second, whether the legal notices issued by the respondent can be construed as notices commencing arbitral proceedings in terms of Section 21 of the Arbitration Constitution. So, my lord, over here, in my present case, my lord, there has been no notice whatsoever. They would, my lord, go down in the arbitral proceedings if it is referred to arbitration, my lord, now as the claimant.
It's a 34 petition which you're talking about. Here the entire thing has not yet started. The arbitral proceedings have not started. You're looking at the time frame of a 34, where he has failed to file the counterclaim during the prescribed period, where he should have filed all the pleadings and proceedings. And he's taking the advantage of Section 14.
My lord,
which the court has done.
What will first one? I'll thereafter.
It's entirely a different scenario.
No, perhaps not. Perhaps not. But the reason why I indicated is
all the judgment from Krish to what he has relied to all the judgment. The issue of limitation is to be decided by the arbitral tribunal.
My lord, unless it's ex facie barred.
It is not ex facie barred.
It's a
Here it is
deadwood.
not. The facts of this case will not be applicable in your facts of the case. The proceedings have yet not started. You're talking about a 34 proceeding.
My lord, no. This particular judgment relates to a situation as to whether the Section 21 notice was issued within the time period, my lord, whether it would be in terms of the Limitation Act or not. Whether that particular notice under Section 21 had been issued within the prescribed period of limitation or not.
What is the prescribed period of limitation? For
my lord, it would, in any event, my lord, it will be Article 55 of the Limitation Act, by which, my lord, they would be, I'll just place that.
My lord,
Show me what is the limitation period in 21 which have been given. Is there a limitation period in 21? After 21 notice, the period is 3 years, not prior to 21 notice.
My lord, it has to be, my lord, in the event the clock pertaining to limitation would stop ticking, my lord, as soon as the Section 21 notice is issued.
That's what I'm saying. That if he does not do it after the 21 notice has been issued.
My lord, I'm not contending insofar as the applicability of the Section 11 application.
Whatever you want to read. What more?
In that case, my lord, if your lordship has already made your lordship mind, I wouldn't trouble your lordship.
Argue the correct position of
my lord,
law.
that is what the correct position of law in my humble submission would be, my lord, because this is a deadwood claim. There has been no notice of Section 20 under Section 21 within the period of limitation.
The period of limitation for 21. What is the period of limitation for 21? Well, show me a judgment which says that you have to issue a 21 notice within such period. Show me.
Well, I'll be relying upon a judgment of this honorable court which deals with several of the Supreme Court judgments, my lord. In fact, what my learned friend had relied upon has been followed up in several other judgments passed by the Honorable Supreme Court. It starts from 2026, Volume 5 SCC. There are catena of judgments on this particular point, but I'm not on that. The point is, in the event of it being a deadwood claim, the notice under Section 21 has to be issued within the period of limitation. Unless it is issued within the period of limitation, then it is to be deemed as a deadwood claim. Your lordship kindly takes up paragraph 3 onwards of this judgment, that talks about the development agreement. Thereafter, my lord, kindly takes up paragraph 5. The disputes have arisen.
This is where the Arif Azim has been clarified.
Yes.
The legal position after Arif Azim is different, sir.
My lord, Arif Azim had been followed in several other judgments, my lord.
That's what the position has changed after that. That's what I'm saying.
My lord, even in take out the judgment. 2026. Just give me a moment. This judgment, after this, the legal position has changed. Sir, after this judgment, the legal position has completely changed. Malad, if your lordship, very well. Malad then keeps the point of limitation. Grateful. The petition is referred to the petition under section 11(6) of the arbitration, section 11 of the Arbitration Conciliation Act, seeking appointment of an arbitral. This is a tribunal, huh? I beg your pardon. What is the arbitration clause?
It specifies a 3-member tribunal.
Are you agreeing to a sole arbitrator? Yes, Malad, I agree. Seeking appointment of an arbitral tribunal for adjudication of the dispute and differences arising out of and in connection with the development agreement dated. What is the date? Whether it's that's 5/2012. Yes. 5th August 2012. It is a case of the petition that the parties had entered into a registered development agreement dated 5/8/2012 in respect of a premises measuring 3 katta, 7 chitaks and 25 square feet, situated at municipal premises number 209, Madhurta, PS, Tiljala, Calcutta. Page. Page 14. Premises number 209, Madhurta, Calcutta. Tiljala, ward number 108, Calcutta. District South 24, Pargana. Full stop. Clause 30 of the said agreement contains an arbitration agreement providing for reference of disputes arising out of or in connection with the agreement to arbitration under the provision of the Arbitration Conciliation Act 1996, with Kolkata being the seat of arbitration. Full stop. Learned counsel for the petitioner submits that dispute and differences arose between the parties in relation to the said development agreement. Full stop. He further states that the respondent had earlier instituted title suit number 720 of 2018 before the learned 4th Civil Judge, Senior Division, Alipur, seeking specific performance of the development agreement. Full stop. The petitioner had filed an application under Section 8 of the Arbitration and Conciliation Act 1996, being miscellaneous case number 125 of 2018. Full stop. By an order dated 4/1/2025, the learned civil court found that application and referred the parties to arbitration in terms of the arbitration agreement contained in clause 30 of the development agreement dated 5/8/2012. Full stop. Learned counsel for the petitioner submits that in pursuant of the said observation, he issued a notice under section 21 on 16/3/2026 and nominated Mr. Arindam Kundu as their nominee arbitrator. Full stop. The respondent by its reply dated 21/4/2026 declined to concur with the said
said nomination and inter alia raised an objection on the ground of limitation. Full stop. Consequently, the parties failed to arrive at a consensus regarding the constitution of the arbitral tribunal. Full stop. Heard counsel for the parties and produced the material placed on record. Full stop. The existence of the arbitration agreement contained in clause 30 of the development agreement. The existence of an arbitration clause contained in clause 30 of the development agreement dated 5/8/2012 is not in dispute. Full stop. It also appears that the agreement has been invoked by issuing a notice dated 16/3/2026 under section 21 of the said act. The parties have admittedly failed to agree for the constitution of an arbitral tribunal in terms of the said agreement. Learned counsel for the respondent states that the present petition is a deadwood claim since the petitioner had not issued the notice under section 21 within the limitation within time. Full stop. He further states that since the claim has become a deadwood claim, no arbitral proceedings can be conducted. Full stop. The objection raised by the respondent on the issue of limitation and that the present issue is since the present arbitral proceeding is a deadwood claim, pertains to the merit and maintainability of the claims. Full stop. The said issue is left open to be decided by the arbitral tribunal in accordance with law. Full stop. At this stage, the scope of the examination under Section 11 of the Arbitration Conciliation Act is confined to the existence of a valid arbitration agreement. Full stop. Upon consideration of the material placed on record, this court is satisfied that a valid and enforceable arbitration agreement exists between the parties and the disputes sought to be raised fall within its ambit. Full stop. Accordingly, and with the consent of the parties, a sole arbitrator is appointed to adjudicate the dispute between the parties. Full stop. Sole arbitrator, Mr. So and so. Give a name. What do you want? Accordingly, and with the consent of the parties, Mr. So and so is appointed as the sole arbitrator. We have agreed. Mr. Rupak Ghosh. Mr. Rupak Ghosh is appointed as the sole arbitrator to adjudicate the dispute between the parties. The learned arbitrator shall enter a reference in due compliance with Section 12 of the Act. Full stop. He shall be entitled to fix his remuneration in terms of the fourth schedule or with the consent of the party. Full stop. With the aforesaid direction, the present petition stands. A copy of this order shall be communicated to the learned sole arbitrator to take necessary steps.
I'm grateful, my lord.
Lordship, I'm for the petitioner, my section 11 application.
Yes.
The service has been refused by the respondent number 1, and for respondent number 2, it has returned with the endorsement left.
Again, Respond number 2.
Will do.
To find his address. Serve him again.
Yes, Lordship. Will serve the man.
Take down. Affidavit of service taken on record. The service report indicates that the respondent number 1 has refused service. Refusal of service is good service. As far as respondent number 2 is concerned, the report indicates that addressee has left without instruction. Learned counsel for the petitioner seeks and is granted one more opportunity to serve upon the respondent number 2 within a period of how much time, madam?
Lordship, 3 weeks.
3 weeks, just after 4 weeks.
Weeks. 13.
Lordship, my Section 11 application. The service is complete on both the respondents. Loan cum hypothecation dated July 17, 2020. The arbitration clause is clause 23.
This page 13, huh?
Yes, Lordship, annexure A.
Loan facility agreement. What is the date of this?
July 17, 2020.
17 July.
2020.
Arbitration clause.
Arbitration clause is clause 23 at page 31.
Which is your clause? Arbitration clause.
Clause 23, Lordship.
24.
3.
And the place?
Page 31, Lordship.
Page?
31.
So that's the clause. The seat of arbitration. The jurisdiction.
That is the clause, Lordship. Jurisdiction is at page 39. The schedule.
Is there any seat of arbitration mentioned?
It is mentioned in clause 23 and 24, Lordship. 24.2 talks about it.
Not the place is not given.
Lordship, it is written that the exclusive jurisdiction to adjudicate any disputes which may arise out of or in connection with the agreement and other related documents, and that accordingly any suit action proceedings together referred to as proceedings arising out
out of or in connection with the agreement, and any other related documents may be brought in such courts, and the borrower guarantor irrevocably submits to and accepts unconditionally the jurisdiction of those courts, tribunals, forums to the extent permissible under applicable laws. And in the first two lines, it is written that forum as mentioned in the loan cum hypothecation schedule.
Yes, where is that?
Lordship, the schedule starts at page 35. And at page 39, clause B5 mentions the jurisdiction. It is Calcutta.
Take down. First paragraph of your petition file. Learned counsel for the petitioner submits that the respondent number 1 had availed financial assistance from Shri Equipment Finance Limited for a purchase of a hydraulic crawler excavator. यहाँ पे page 37. Model SY 210 hydraulic excavator. By executing the aforesaid loan cum hypothecation agreement, wherein the sum of rupees 4420000 was financed, repayable in 48 equated monthly installment of rupees 121600 each. Full stop. Respondent number 2 executed the agreement as guarantor and undertook joint and several liability for repayment of the dues. Full stop. It is further submitted that by virtue of the settlement agreement dated 30th September 2021, the right, title and interest of Shri Equipment Finance Limited under the said agreement stood assigned in favor of the petitioner. Full stop. According to the petitioner, the respondent committed persistent default in repayment of the loan. Full stop. A demand notice was issued on 31st May 2024, recalling the loan facility and calling upon the respondent to pay the outstanding dues. Where's your 21?
Lordship, at page 81.
The learned copy of the petitioner states that thereafter the petitioner invoked the arbitration agreement. Thereafter the petitioner invoked the arbitration clause as mentioned in the lease cum hypothecation agreement
Loan cum
by
hypothecation.
issuing a loan cum hypothecation agreement by issuing a notice under section 21 dated. What is the date of this?
8th June 2024.
8th June 2024. Full stop. Learned counsel for the petitioner states that the respondent neither responded to the said notice nor took any steps for constitution of an arbitral tribunal to adjudicate the dispute between the parties. Full stop. Learned counsel for the petitioner further states that the arbitration clause as contained in the loan cum hypothecation agreement provides for resolution of disputes between the parties through arbitration and stipulates Calcutta as the seat of arbitration. Full stop. Considering the materials placed on record, this court is satisfied that an arbitration agreement exists between the parties. Full stop. Disputes have admittedly arisen in connection with the agreement. Full stop. The petitioner has invoked the arbitration agreement by issuing a notice under section 21 upon the respondents. Full stop. The respondents have failed to act in terms of the arbitration agreement by not consenting to or responding to the appointment of an arbitrator within the statutory period. Full stop. Under these circumstances, accordingly, this court is satisfied that the present case is a fit case for appointment of an arbitrator. Full stop. Hence, so and so is appointed as an arbitrator, as the sole arbitrator to adjudicate the dispute between the parties arising out of the loan cum hypothecation agreement dated 17/7/2020. All issues relating to arbitrability, maintainability, admissibility of claim, limitation, and all other issues are kept open to be urged before the learned arbitrator. The learned sole arbitrator shall enter reference in terms of compliance with section 12 of the Act. Full stop. He shall be entitled to fix his remuneration in terms of the fourth schedule of the Act or with the consent of the parties. Full stop. With the opposite direction, the present petition stands to proceed.
Hold on.
The good part was this make copy I can take right because I have or if you
How many years you have put in?
yes, sir. 45 minutes.
The point?
But you may suggest an Advocate Debani Banerjee.
Give your name.
Phone number.
Grateful.
Yes, sir.
Now 14.
Well, at 14, I beg to appear on behalf of the petitioner. My lord, this is the matter. On the last occasion, my lord was pleased to direct us, was not happy with the language that had been used in the section 21 notice with regard to the jurisdiction. Instead of Kolkata, we have used Dehradun. Now, my lord was pleased to direct me to come back if I can satisfy your lordship. Now, my lord, am I audible, my lord?
Yes, yes.
Now, my lord may be pleased to recall that the respondent, after having terminated by the principal employer, in turn he has terminated my contract with some allegations on me. So my cause of action is illegal termination and some monetary claim. Now the purchase order, that is
Mr. Mukherjee, I had very clearly asked you to get an instruction as far as your 21 notice is concerned. Your 21 notice is faulty.
My lord, I am trying to satisfy your lordship that it is not faulty. My lord, or my lord may my lord may kindly allow me to come back physically before your lordship on Wednesday, subject to my lord's convenience.
Lord, this is no more rescinded, your lordship. Lordship, the intent and scope of section 21.
I am covered by judgments. I will try to satisfy your lordship.
I am covered by a recent judgment, your lordship, only on the scope of 21, your lordship.
I'll also do.
Lordship, para 178 at internal page 145.
May I know the citation from my learned friend?
2025 9 Supreme Court cases, page 76.
Lordship, only one para at page 145 internally, para 178. It's the fifth last page, Your Lordship.
946. 946.
145 para?
Para 178, Your Lordship, at the top. It is noteworthy to mention that Adavya project acknowledges that although the decision of the Delhi High Court in such and such is correct insofar as it holds that some of the functions that a notice under section 21 of the 1996 Act serves inter alia includes. Lordship, on 2 points I'm contesting the 21. Roman 1. Informing the other party as to the claims which will enable them to accept or dispute the claims. I had indicated, Lordship, claims are not specified in the notice. And Millard, Roman 5. Or for triggering the court's jurisdiction under section 11 in case the appointment procedure fails. So, Millard, the section 21 notice that my learned senior is relying upon in this application before your lordship under section 11 it, gives the jurisdiction to courts in Dehradun. The section 11 court in terms of courts in Dehradun will be the Nainital High Court. So your lordship, this section 11 application before your lordship is not maintainable on the behest which is born out of the section 21 notice relied upon my senior. Lordship, this section 11 is not maintainable. The 21 is bad.
Yeah. Mr. Mukherjee, you come back on Wednesday, you want a dismissal on this? Good. You are insisting that I should dismiss.
My lord, I am sure that my lord will be pleased to allow it.
Look at
after hearing me.
21, Mr. Mukherjee. If you're 21, please read your 21. Huh? The
I'll show.
seat of
I'll
arbitration
show.
to be held
Yes,
at
my lord.
Dehradun as per the address. I mean, what can be
No,
more
not
specific?
at all. Not at all. Kindly come. Very well, my lord. Kindly
Right.
come to.
You come back on Wednesday, we'll see. Not today.
Very well, my lord. Grateful, my lord.
Phone number 15.
Milord, I appear for the respondent. Respondent number 1.
I'm appealing for the petitioner. Section 11 application for appointment of arbitrator. The agreement, this matter has a short history. It was filed before the Bombay High Court just to place the facts. From there, we have taken a leave and we have come to this. That's the simple thing. This is a matter arising out of a simple loan transaction between an individual and a company. The money was loaned at 99 lakhs on an agreement. That agreement had an arbitration clause. And the agreement obviously contained the terms of interest and the time period, 2 years and all that. But there are letters, epistolary communication between parties which clearly spell out the intention also. The money was invested by the company in certain business endeavors. We are before your lordship, because they are not repaying the interest. They have made default in payment of interest. They are not repaying the principal. And the time of contemplated within the contract has expired. We gave him the notice under section 21 for appointment of arbitrator. The agreement says arbitrator of my choice because I was the loan. They did not agree, and therefore we are before your lordship for appointment of arbiter. This is the long and short of the case, my lord. Every other thing, my lord, is matter of arbitration. I cannot start that entire argument here.
My only ground of objection is the maintainability because section 21 notice is faulty. But because section 21 notice was issued on the basis of the arbitration clause on 3 entities. One is the respondent number 1. 2 others were not part of the arbitration agreement at all. Even before your lordship, in the section 11 application, various respondents have been arrayed as parties who are not parties to the arbitration agreement. Well, section 21 notice has been, arbitration clause has been invoked against non-signatories to the arbitration agreement, non-parties to the arbitration agreement. The petition or the...
This is a I do not want to interject.
No.
The company is the loaner who has taken the loan. The company, as your lordship knows, speaks to the board of directors. Directors come, directors go. My learned junior has walked the extra mile to obtain names of the present directors in the list of directors with the ROC. I have put in Bombay petition, but I cannot change it completely. I have to bring that before your lordship. To be fair enough, I have added the names which presently appear. Now, if they take the point that the directors have walked out and in of the boardroom, and then the monies they want to keep on that context, unjust enrichment, what else? These technical matters don't come in the appointment of an arbitrator, even in arbitration proceedings. The spirit of Arbitration Act will be completely rendered osios
If my lord, these technical points and they want to say that I don't want to pay the money. That is the whole thing. That is why directors give array of parties. Array of parties. If my claim is not at all maintainable, let him take the point before the arbitrator. Why make a mess out here? He has no points in section 21. He has no points in limitation. He has no points in competency of the arbitrator being appointed. He is not on the point of the arbitration clause being rendered extinct.
You're appearing for the first time in.
My name is Debjyoti Vasu. I have appeared before your lordship and your lordship, but not my privilege. Your lordship was with Justice Bakchi in that. That I have only one privilege. That's why my privilege.
Mine is high pitch.
Pitch to that, Lord, I have always submitted. Lord, pitch is just a style. It doesn't influence the court at all.
It influences me.
Oh, I'm deeply. No, the high pitch is not meant for anything else.
High pitch in my court is something.
I'll maintain that. I'll maintain that.
I'll subscribe to either for myself, not for anybody else.
That is absolutely acceptable to me, Lord. Absolutely. With due honor, I'm accepting it. Lord, kindly forgive me, Lord.
Let's keep it easy. Let's keep
Yes.
And simple.
Yes.
Yes. Show me the agreement, because one of the points is that if you are not a signatory, that is something which this court will look into.
Yes.
Because the only aspect which this court looks into, as far as 11 is concerned, whether there's a valid agreement between the parties.
May I place the clause, my lord?
Yes, you show me the clause,
Page
you show me
68,
the parties who are there, and then we take it forward.
My lord, kindly take page 68, my lord, of my lord brief of documents, my lord. Lordship got it, my lord?
Yes.
Page 68, my lord, the loan agreement is between Messrs. Ampere Building Services Private Limited, who is the respondent number 1, and Mr. Avinash Pandit, petitioner, for whom I am appearing. There are no other parties, the lender and the company. Now, my lord, these are the parties, and my lord, we have annexed the arbitration clause, my lord.
So you are the lender for this 99.
I am the lender. But I'm deeply obliged, my lord. I am the lender. I lend the money. Then, my lord, this money, the loan is second clause, my lord. If you lordship kindly take the trouble, my lord, the said loan is required by the borrower for a period of 2 years. That is the time period for. Then, my lord, if you lordship kindly flips the page and comes to page the third clause. This is the borrower hereby agrees and undertakes to return the loan of such and such amount within an aforesaid period of 2 years as per the demand of the lender. So it is my demand which kicks off the claim.
Yes.
The terms and conditions of this agreement are arrived at mutual consent. Then, my lord, the borrower knows that the business of the lender knows the borrower business. And then 7, my lord, is the clause for arbitration.
Yes.
Arbitrator to be appointed by the lender. So I had the first right to appoint an arbitrator, but that didn't work out, my lord. So these are the, and because of the company being the sole party, my lord, I had to bring on record the company and a few directors who were there before the Bombay High Court, and now.
So now let's see who are the signatories to this. So
The-
this is the agreement. Who
Only-
are the borrower?
Yes, my lord, signatories. Signatories, lender Avinash
That's you.
that's me, and borrower is there, my lord, Ampere Building and Services. Somebody has signed with the symbol of that company, that seal, company seal. Somebody has signed, my lord. I do not know whose signature exactly. That Sarkar is visible a little bit. Sarkar. Some Sarkar, my lord, Mrinal Sarkar happens to be, respondent number 4 happens to be the current director. So, but this is Mrinal's signature or not, that my learned friend will on the other side will tell me. No, I don't know. This is the fact, my lord.
And here you have made parties. Who all are parties here?
I have made party, my lord. Ampere is there, then
Fine.
4 Mrinal Sarkar, 5 Shorben.
Shukla Mukherjee.
Shukla Mukherjee erstwhile. Subra and Shukla are erstwhile. 2 and 3 are erstwhile, and 4 and 5 are the present. This is the position, my lord. And I have made this erstwhile because the erstwhile were there directors, live directors, effective directors before the Bombay High Court. Now, very recently, my lord junior did the That is the 4 and 5. Page 21 is that.
Mr. Dasgupta, who are the directors of the company right now?
But as the petition speaks, one of the respondent numbers 4 and 5 are the present directors of the company. Now, my Lordship has seen the arbitration agreement. The respondent numbers 2 to 5 are not parties to the arbitration agreement at all. Now, my learned senior friend also does not say that they are signatories to the agreement.
The company has to be.
Yes, the company is the party to the arbitration agreement. So, if the arbitration clause,
The directors will be included.
the directors are not there in personal capacities. The directors are not personally liable.
As directors of the company, sir.
But my respectful submission is, but if the company, yes, but the directors cannot be independently arrayed as parties because the directors are not parties to the arbitration agreement. It is only the company. So, my lord, it cannot be.
He can put it Ampere through its director, so and so. That is how you want it.
No, it is the company. If the petition would have been framed in the manner that there is only one respondent director represented by the company represented by directors, then it would have been all right. But the directors have been made separately parties, and it has the arbitration has also been invoked separately against the company as well as the directors. So that is why the invocation itself is faulty, is defective, and this Section 11 application based on that invocation is also not maintainable.
Is 21?
21 is below at page 84. Is a Section 21 notice, my lord.
But you will see the Section 21 notice. It has been addressed to three entities. One is the company, addressee number 1. 2 and 3 are respondent numbers 2 and 3 before your lordship. Now, in the petition, more respondents are being added because they are according to the petitioner, they are new directors of the company. This cannot be allowed. This is not a suit, and the case has not been made out that they are personally liable for the acts of the company.
There is not a single statement holding them responsible personally, either in my application under Section 11 or in 21 notice.
May I complete?
The technical appearance will not be of concern. Only substantially what I have stated will be before the arbitrator. If he wants that through, as your lordship,
it is not about.
Your lordship can observe that I will not lay any claim against the person. I only want to get my money back. That's respondent number.
No, that is fine. I'm not making any arguments on my merits.
Just change the cost type. Make it the petitioner number 1 through its directors.
I'll do that. May I file to cut short the technicalities, may I file a fresh cost title which will be treated as the one with your lordship's kind leave? Then lordship kindly give me that leave, my lord.
But still then the Section 21 notice will remain faulty. That is the difficulty which the petitioner may face. But I'll reserve my right, my lord. I'll take all these points on the next day.
My lord.
Respondent number 2 and 3 were directors of the company. He has issued it to them. Why is it faulty? At that point of time,
they were directors. They were
separately from them.
No.
That we'll deal with.
Yes. I'm obliged.
Yes, but they are not parties to the arbitration agreement is my contention.
That's all right. They are acting in the capacity of directors. And it's written over. Look at this director. You please have a look at 84.
Yes, my lord. I have seen. My lord, I have seen they are being they're described as directors. But my lord, the agreement cannot be enforced against them. It is only the company. It is only the company.
As far as arbitration is concerned, they'll go with the company through its directors.
Yes.
But not against them separately. That is my contention.
I don't want to.
Well, let them amend the cost title, and thereafter, I'll come back.
Time of entering into the agreement also, lordship, respondent number 2 and 3 were not the directors of the company, lordship. This is my instruction.
Your instruction is wrong. Take note. Learned counsel for the petitioner seeks and is granted liberty to amend the cost title within a period of 1 week. Let this matter be listed after a week.
May I hand over the Wakala matter affidavit of competency, lordship?
File it to the registry.
May the affidavit and service be kept on.
You do it after that.
Great.
I'm grateful.
After 1. No, you keep it after 1 week.
One. Would you lot to be kind enough to fix particular date?
Fix it after 1. Give a date.
I'm doctor. And not kindly do not take me any. regarding my intonation. That is a natural instinct, my lord, with utmost respect always. But our seniors have taught, and we follow the old school, that the court is to be kept at the highest pedestal.
Best it's a good. When we keep things light,
Lord, I also want to keep things light, my lord.
work out well.
It works out best. I'm deeply obliged, my lord.
Thank you.
And now 16.
May it please, my lords. My lords, this matter is going on ex parte, my lords. The respondents haven't yet entered appearance, but my lords, pursuant to the last date of hearing, the petitioners have invoked arbitration, my lords. So, my lords, I have no further reliefs to pursue in this matter so long as my rights can be reserved to take it up when the tribunal is constituted, my lords. After the statutory period is over, if they don't respond, then we'll have to move the court to appoint.
Withdraw this section 9.
Yes, my lords. I'll withdraw this. I have no other reliefs to press. Yes.
17 before the learned tribunal whenever it's constituted. Learned counsel for the petitioner seeks to withdraw the present petition with liberty to file appropriate proceedings in accordance with law. Same is dismissed.
Grateful, my lords. If my lords may just consider adding that, my lords, arbitration has been invoked. But my lords, just that one line, my lords. I'll be grateful.
That the arbitral proceedings have been invoked or the tribunal has been constituted?
No, my lords. The 21 has been issued, my lord.
Arbitral.
So I've issued a notice for invocation.
Learned counsel for the petitioner states that he has invoked the arbitral proceedings by issuing a notice under section 21 of the Arbitration Conciliation Act. He states that he does not wish to press the present petition and reserves his right to file appropriate proceedings before the concerned tribunal. Full stop. The present petition is dismissed and withdrawn with liberty as to.
I'm so grateful, my lords. I'm so.
May it please, Your Lordship. So this is my section 9 petition.
Your Lordship, upon instructions, I'm submitting that the advocate on record for the respondents couldn't come to court because of some personal difficulties. Your Lordship, as per my instructions, there has been a bereavement in his family.
All right, not today.
My Lord, I appreciate that there's been a bereavement and I would not press, my Lord. There are certain ad interim reliefs that I was seeking at this stage, and it's would it be Your Lordship's pleasure to then have this matter on Monday, my Lord, or any day subject to my Lord's kind convenience in some priority, my Lord?
Monday.
I'm so grateful.
You invoked section 21?
No, section 21 notice had been issued, but insofar as that is concerned, I understand there was some dispute with regard to the receipt thereof. Pursuant whereto, I had filed a section 11 as well, which was withdrawn subsequently. So
Why was it withdrawn?
I'll tell you, Lordship, because section 21 notice that was served upon them, there's dispute insofar as the respondent stating that they are not in receipt of the section 21 notice. My Lord, insofar as that is concerned, a fresh section 21 notice will be issued from our end, my Lord. That is what I've been instructed, my Lord. Over the weekend, I will get that done and I'll approach Your Lordship.
Did you issue the first 21?
My Lord, this is issued on 30th January 2026.
No urgency as such.
My Lord, I'll tell Your Lordship will kindly allow me once. This matters some checkered history because Your Lordships have already been in session of one round of Section 9 petition, given me reliefs. Insofar as operation of bank accounts are concerned, subsequently we find out that there's nothing in the bank account.
From January you're not doing
My Lord,
anything.
may I come on Monday and my Lord apprise Your Lordship, my Lord? Your Lordship will allow me 5 minutes, my Lord?
There's a bereavement in the family. Keep it after 2 weeks.
Very well. I'm so grateful.
2 weeks.
Your Lordship's having the matter after, my Lords?
2 weeks.
2 weeks. Well.
And now 18. My Lord, item 18, 19, and 20, my Lord, may be kept on Monday, my Lord. These are post-award section 9, my Lord. Your Lordship not has raised certain points, my Lord.
Is the award a unilateral award?
Lord, it was by the ODR tribunal, so Lord, we will try and satisfy Your Lordship on that.
Sarkota's way to deal with your section 9.
That Lordship keeps it on Monday, my Lord, we'll try if, my Lord, if we...
Right.
Lordship keeps it on Monday, my Lord, we'll
make an attempt. My lord. Either we persuade the client or we persuade your lordship. These three, my lord, could be kept on Monday, and the rest may come up next Friday.
Dealing with the unilateral appointment. Very innovative, Mr. Singh.
ये तो post about.
Which ones you want on Monday?
My lord, 18 to 20, my lord, and 23, 26, 28, and 32. No, they are similar type, so. No, I give the list, my lord.
Just give the
18, 19, 20.
Eagle Monday.
18, 19, 20 then.
This is literally, like, you can't hold it like this, hold it like this. No, I admire your.
No, the rest, my lord, may come on Friday, my lord. The other matter for those, just those. Eglo, Paki Chota, next Friday. Not Friday, not next Friday. I'm grateful.
Is the roster changing next Friday?
My lord?
The roster changing next Friday?
No. I don't think not anything is happening.
বয়স সবই তো সীমা তো 24টা আছে না
I'll come back in fact. उसको organize कर देना Development of
Sorry, my lord, I couldn't follow. My lord.
development of municipal premises 4, right?
Yes. Now, this has the arbitration clause, which is at clause 14, page 48. Now, there are twofold obligations which the owner had. I'm for the developer. Twofold obligations which the owner had. One, my lord will find, is his obligation at page 38, 5 Roman 2 clause, to settle with all the tenants, occupiers, at its own cost and efforts, and to hand over the complete vacant possession of the said premises to the party, to the other part, within 90 days of the zero. I'm not on the timeline as of now. This is one obligation. And the other obligation, my lord, will find at page 35, clause M. Security deposit, interest fee refundable superior being a total sum of rupees 2 crores. And my lord, may kindly come to page 36, clause N. One part shall refund the aforesaid interest fee refundable security deposit to the other part, that is the owner to the developer, rupees 1 crore within 30 days of completion of superstructure of the proposed building, adjusting to the such and such. Now, what has transpired here? Superstructure has been completed. 1 crore refund has not come, despite of demand. In between, what has happened? This is my specific case. The owner, that is the respondent, he did not have the funds to settle with the tenants. It was also his obligation to make payment of all the areas of municipal taxes and the like and other charges. He did not have the funds. He approached us. He has borrowed money from us for this purpose in aid of development, so that he can discharge his obligations under the development agreement. He has given written acknowledgements of
That's not part of the development.
Well,
that's not part of the development agreement. That is probably a separate agreement you have entered into.
But that is in aid of development.
Okay.
That is in aid of development. The reason, my lord, will kindly comes to my specific case here. Para 18, page 7. The respondent, citing paucity of funds, had requested the petitioner for financial assistance as and when necessary in order to enable the respondent to discharge his financial and other obligations under the said development agreement. It was also represented by the respondent that he had other dues towards so and so for other property, and unless it was clear, he would not be in a position to arrange further funds for discharging his financial obligations under the development agreement. Had assured the petitioner that this will be refunded with 14% interest per annum, also able to refund the amount upon demand being raised by the petitioner to that effect. Now, apropos this, if my lord kindly comes to the monies which have been given, kindly comes to the confirmation of the one of the written acknowledgements, page 181. Page 181. There are several acknowledgements. Kindly comes to page 181. This is the second volume, volume 2.
Yes.
As per our verbal discussion over the phone, we hereby request you to make payment of rupees 10 lakhs urgently, which we need on account of settlement of tenants. That is one of their obligations under the development agreement. We hereby assure you that this fund would be utilized for the said purpose, and also it would be the interest bearing as per earlier understanding. We further would like to put it on record that as soon as we receive the consideration against booking of the flat from our allocation area, we shall refund you the additional amount paid to us along with applicable interest thereon. Please so and so RTGS. So this is in aid of development for settlement with the tenants. He doesn't have the funds, and he says that once he has his own allocation, once I sell from their allocation, I'll pay. And there are several letters to that effect. For an ad interim stage, I'll not trouble my lord with each and every letter, but what I'll show is that in the meantime, what had also happened, that superstructure was constructed, and for which we had raised a demand. The superstructure was concerned on 13th of December 2024. We'll find page 197.
197.
Page 197, that when we raise our demand, because that is directly under the development agreement. And there's a consular demand in respect of the other payments. Kindly see the last paragraph, page 197. It is also important to note that on completion of the superstructure by end of this month, you will be liable to refund the 50% of the total security deposit amount, that is rupees 1 crore, to us in terms of the registered development agreement dated 28 January 2020, executed by and between us for the development of your property. Thereafter, so this was also, he was put on notice that this was done. This money has also not come in. About 5 crores, that is with interest, there is 14% interest, which has been acknowledged, is outstanding on his part. Now, in the meantime, there has been supplementary registered agreements which has been entered into, by which his allocations have been determined in the building which is under construction. These supplementary agreements, my lord, will find at pages 13 July 2022, that is page 102. 102, yes, that is one. And then followed by 28 February 2024, where there are 2 flats which were exchanged between the owners and the developers allocation, page 122. So his allocation in the area, in the property is also now determined. He was supposed to pay from one of his own acknowledgements out of the proceeds that he receives from his allocation. Now what he has done, he has executed a conveyance in respect of one of the flats. My lord will come to page 264, 14 January 2026. Yes, volume 3. January 2026. This is even after our demand notice. I'll show our demand notice. 14 January 2026. And he has received a consideration of rupees 2.5 crores. My lord will find from memo of consideration 301.
So what is he selling? This deed of conveyance?
He's selling one of the flats in his allocation, which he was supposed to repay, one of the that he will sell off his flats and repay my dues. Nothing happening. So I have more than 5 crores outstanding. There are written acknowledgements. I've just, for this, since we are at the ad interim stage, I've only shown, my lord, one of the letters from his side. There are demands from our side. There is, under the agreement, 1 crore he was to otherwise pay me upon completion of superstructure. That is done because he's selling flats. So that is done long back. That has not happened. That is part of the 5 crores which is outstanding. So, my lord, I need to secure my claim because I'll be going into arbitration. There is an arbitration clause. There are other claims because he has also not settled with 2 of the commercial tenants, and I have the commercial space which is lying there in the property.
When did he file this?
This was filed on, my lord, I'll just give the date of the affirmation. I'll just kindly come, allows me.
First week of July, I think.
Yes. This was affirmed on 8th of July 2026. And there's a consolidated demand notice which I had given earlier. Yes, page 246. Let him not part with the money. At least the money which he's receiving, my lord, or my lord, at least his immovable property is his share in the property, because he has himself, there are several written acknowledgements that on demand he'll pay. I'll show furthermore. Yes, page 185. Yes, kindly comes to page 186. Page 186, where he says I'll repay on demand with 14% interest. Page 186. But this is my letter, putting it on record, and then his acknowledgements. Yes, page 185. Page 185, kindly come. Sorry, not my mistake, not 186, 185 is his letter. December 2022.
Yes, sir.
But kindly gives me 5 minutes. I'll first take him through the pleadings he has taken, but then I'll show 4 or 5 documents. Then I'll make.
Time. Who's rushing you?
Sir. You kindly first takes up para 4
of the petition.
That it says that sometimes in the year 2019, the respondent hearing through one of its directors, Mr. Suresh Kumar Goyal, had approached the petitioner, claiming it to be the sole and absolute owner of the property, being premises number 4, such and such, representing that he intends to develop the same jointly with the petitioner. It was also represented by him that there are several tenants at the premises, both residential and commercial, with whom the respondent was in a position to enter into settlement and receive the possession of the respective occupied portions and hand over the same to the petitioner in order to enable the petitioner to carry out the real estate development at the premises. So the development agreement was contingent to us settling the tenants first. That is one of the contracts first. But then kindly comes to para 13. Even though the joint development agreement was executed on 28th January 2020, it was only paragraph 13, page 5 of the petition. First volume.
Page 5 is missing, sir.
Page 5.
Page 5 is missing.
This.
Where is it?
This is after. Apologies, my lord. This.
After page 4. No, it goes, look at this page numbering 3, 6, 5, 7.
Only my lord grants. This is this should have been seen, my lord, before filing. This should have been seen.
Please just change it so that it becomes easier for me.
My lord, we'll make the kindly grants leave for making the necessary corrections in the and keeps it, my lord, on Monday, my lord. Monday.
Just do it now.
check
The court observes that the page numbering of the petition is not appropriate. The learned counsel for the petitioner seeks and is granted liberty to put the same in order. List on it. Just put that in order so that.
My apologies, my lord. Grateful, my lord.
Just see if there are any other pages like that, or it's just one page.
Check all the annexures.
Just check the annexures.
Yes, all the annexures. Just if this.
No,
plus, just check all.
Just check whole.
25.
Yes.
Thank you, Lordship. My lord, I'm for the applicant.
I'm for the respondent before my learned senior friend begins. And I'm in some difficulty today. I'm led by two seniors, my lord. Both of them are not here.
Not good enough.
Yeah, that is exactly what, my lord, I was going to say. He's far
Chayan
better.
Gupta and Mr. Chayan Gupta and Mr. Jishnu Chaudhary are leading me, my lord. If it could be
Lord,
placed
he is
another day.
totally competent.
No, to take a corner.
My lord, very small application. I am the lender, and there is a lender's loan cum guarantee agreement as well as a deed of hypothecation. My lord, I have no security. That is my only difficulty. There was a collateral security of 70 odd lakhs in a fixed deposit, which I have already invoked. And after that, my lord, my outstanding is 3.62 crores. I have issued a letter of a loan recall notice. They replied much later, which I could not annex, my lord, because it has come only a couple of days ago. I can give that to your lordship. I have a copy. And my essential, and we have an asset tracking report to show, my lord, that there are unencumbered assets, almost 5 immovable properties. So, my lord, I'm asking for a security, and my lord, my arbitration is going to begin any moment.
We'll make
Already issued.
that
Issued at 21.
Yes, my lord, I've issued. My lord, yes, I have the loan recall
We
notice.
have submissions to make on the 21 as well as the petition and the pleadings. Kindly keeps it some other day.
My lord, I have not issued a 21 notice. It is not on record, my lord. So I will have that issued as well. But my lord, limited trade, my lord, till that happens, 3.62 crores, my lord.
If
And
it's not issued 21, it means you don't have any urgency in the petition.
my lord, they have responded, my lord, that it is a loan. It is a section 21 notice, my lord. I will just yes, my lord, it is a. My lord, we have issued, my lord. It is not here, my lord. I'll bring it. My My lord, when is lordship keeping it? My lord, tomorrow I have some personal difficulty, lordship. My lord, tomorrow I have some personal difficulty. If
Monday,
it can be.
Tuesday.
Tuesday. No, not Tuesday. Wednesday.
Wednesday. Great for
Commercial matters. Wednesday.
Great for lordship.
Great for me.
I got 33.
I am for the petitioner in this matter. Only thing, my lord,
For the defendants, I would request my learned friend to serve me hardcore because the drive link they have shared is not accessible to us. I have.
But I'm led by Mr. Sen, Mr. Shako Sen. He's in the online platform. He's not in Calcutta. So, my lord, if my lord kindly keep, I'll serve it in the meantime. If your lordship keeps it on Tuesday, my lord.
Tuesday, not
Wednesday, my lord. Wednesday.
But I am sorry, my lord, I'm joining online. But this is a unique matter.
Mr. Sen, wherever you are, please enjoy your day and the weekend. We'll have it on Wednesday.
Well, kindly keep it on Tuesday in that case, my lord.
Tuesday, my lord doesn't.
Online service.
Wednesday, my lord is keeping it.
Wednesday, fine, well, obliged.
My lord.
Just give a copy also. Give a What's your name?
My lord, Mr. Rupak Ghosh.
Yes. We appointed you today.
Grateful, man. Grateful.
Sorry to disturb your lordship, my lord. Item 25, my lord, I need your lordship leave to file the wakalatnama, my lord, in the meantime. By Tuesday, the respondent advocate is not here today, my lord, just to leave to file wakalatnama.
Why do you need my leave? Why can't you file it in the registry?
We'll file it in the department within Tuesday, my lord.
34.
My lord, I am appearing on behalf of the petitioner, my lord.
Service?
Yes, my lord. If you give the service to my lord, I take an updated track report. My lord, we have served them, but it got returned, my lord. This is the updated track report.
You have to serve
Door
them.
locked.
Returned as what? Refused? Door locked.
The door is locked, my lord. It's canvassing on 18/7/2026. Kolkata GPO door is locked, my lord.
Door locked is not good service.
My lord.
Second is address is absent. Just get it refused.
And my lord, then in the second attempt it's done, it is called addressee is
See,
absent.
This one, the one I have is addressee absent. All right.
Yes. Addressee absent, my lord.
This is also addressee absent.
Yes, my lord. This is also addressee absent, my lord.
Find the address of the person, serve him. Sufficient address.
My lord, if you come to my lord, if I put the factual matrix, if you permit, my lord, the agreement demonstrating that address only, my lord, which is in page number 27.
No such person in the address. Look at this.
My lord, this agreement is demonstrating that address. So, my lord, we have
to find, sir. Have to do an effective service.
My lord, that address.
I can't find you.
My lord, if you permit, my lord, I come back. I will serve them once again. Try to serve them once again on the same address, and kindly.
Please get an endorsement that he has refused or something, or door lock will not help you. Or otherwise, publication.
My lord, if it's the urgency, my lord, if you say a prime officer, they have terminated our agreement. So if it is not, the third party right will be created on the subject matter of the incident.
Give you 1 week. What can I do? You have to serve them. I'm not doing
My
an
lord, we have tried, my lord, the address which is canvassing in the agreement, my lord.
Sir, I can't get you the fresh address. You have to get the address. Learned counsel of the petitioner seeks and is granted.
My lord, if
opportunity to serve upon the respondent within a period of 1 week, list after 2 weeks. Keep it after 2 weeks.
My lord, if I seek some indulgence, my lord, if you kindly keep the matter on Wednesday on the top of the list, it will be, my lord, I say humbly praying, my lord.
Can't keep it on the top of the list, but I can keep it on Wednesday. But Wednesday, you'll not be able to serve him.
My lord, through mail we will serve it, my lord, if you fairly keep in the top, because there is the urgency, my lord. Otherwise, my lord, I'm just humbly praying for that, my lord.
After next week, Monday. Not this week, the coming week, Monday.
Grateful, my lord.
And now 35.
And I'm appearing for the respondent, my lord.
Lordships, I'm being led by Mr. Chaudhary in this matter. He's not here today. If your lordship kindly grants us a note today.
Not today, Monday.
My lord, no, my lord. If your lordship then kindly keeps it on Thursday, my lord.
Thursday won't be possible. Then Wednesday?
My lord, Thursday or Friday, my lord, or next Monday, kindly, my lord. Friday, my lord. Very grateful. Grateful, my lord. Grateful, my lord.
36.
36, Your Lordship, I am appearing for the petitioner.
For
Well,
his accommodation, because I'm led by Mr. Shuddhashatto Banerjee, my lord. He's on his legs before division bench, my lord.
Your Lordship, we are also led by Mr. Senior Counsel, Mr. Mainak Bose. We are requesting, can this matter be listed tomorrow, Your Lordship?
Not tomorrow, my lord. Kindly take it up on Monday.
Not tomorrow, Monday.
If my advocate records
My lord,
agrees
in
to it,
that
Your
case, my
Lordship.
lord, can it be slightly higher up in the list, my lord?
I don't have any objection.
Why higher up? It's
My
coming.
lord, there's some urgency in the matter, my lord.
My lord, urgency, I will indicate.
And Your Lordship, Monday is also monthly list day. So we were requesting for that purpose.
Then Wednesday. Next.
I have no
My
problem.
lord, Monday, my lord.
Wednesday.
Delhi list. Wednesday, Delhi list.
Lord, Tuesday, my lord, if I may pray, my lord.
Tuesday is non-commercial day.
Grateful.
Grateful, Your Lordship.
Motion under section 14. Item number 37.
Lordship, in this matter, your Lordship had already appointed Mr. Subhashish Shenmukto as the arbitrator. Unfortunately,
What
he has
recent development
recused.
has happened, perhaps my learned friend is not aware. My lord, I just received, my lord, a message. My lord, the dispute between the parties was with regard to, my lord, we had invested 3.22 crores in respect of the respondent, giving them 2 work orders. Now, my lord, I have just received a message that we have received the amount of 3.20 crores. So that is why, my lord, I believe the disputes are settled. She says that she does not have
I have no such instruction. I have no
That is
such
why, if that is
instruction,
the
Your
case,
Lordship.
because it was my section 11 application, I'll withdraw it. So that is why, my lord, I'm seeking a day's time. Well, let us come back on Monday or Tuesday.
Monday. Come back with the.
Yes.
Be on the
Then
same.
keeps it on Tuesday, my lord. Then keeps it on Tuesday.
Tuesday is non-commercial.
Wednesday.
Non-commercial day,
Because
Wednesday.
I'll take
Very
a
well.
formal,
We'll
my
come
lord.
back.
Yes. Yes.
We'll also ascertain and come back with it.
Yes.
There's no point, my lord,
Deeply obliged.
appointing somebody and then, my lord.
Yes.
Obliged.
With my lord's permission, my lords, I
My lord,
appear
I
in
appear.
2 items. Item 38 and 39, my lords. I appear for the petitioner in the matter.
I appear for the respondents, my lord. May I request my learned friend to supply a complete copy, my lord? The brief they have supplied to me is incomplete. Most of the pages are missing.
We'll give a copy. We'll give a copy. He had a copy. These a copy.
Lordshipson can issue notice, formal notice to them.
30 to 39, I'll give complete copies to my lord.
This is
Lords then can issue formal notice to them and let them then file their response to it.
no need for a response. What is it? What is the petition?
Lords, the issue is, if I may say so, my lords, am I audible for your lordships?
Yes.
Your lordships, what has happened is, at page, if your lordships can first take item number 39, I may only request that for a minute. Item 39, if your lordships have that.
Yes.
If your lordships will have page number 20.
Yes.
Because an erstwhile arbitrator had reclused himself, saying that he is not well. And after recording all the concerns of the parties, a retired Chief Justice of this Honorable Court, Justice Girish Chandra Gupta, had been appointed as an arbitrator. Your lordships will find it at page number 22.
Okay, that
Para
now.
6 of that order, my lords.
Yes.
If your lordships have Justice Girish Chandra Gupta, former Chief Justice of Calcutta, as the arbitrator to arbitrate upon the disputes, and thereafter he has to comply with Section 12, and he will fix his own remuneration as per the schedule. Now, what transpired thereafter, my lords, is slightly which makes us come here before your lordships, is an email which was received by the learned arbitrator. If I can just take that, your lordships, to that issue for a minute, and then I will just come where this emanated from.
Yes.
Lordships, we had requested a Section 12 declaration by the learned arbitrator that please provide us with the Section 12 declaration. If your lordships will come to page number 61 of item 39. Annexure G.
Yes.
Lords, the council writes to the learned arbitrator to please provide disclosure under 12.5. And the learned arbitrator, if I may just see it, he says, I think I have already done it. Have you checked with the registrar OS? What makes you inquire about the same? Please let me know. In case I have not, I shall do it unless the parties are interested. Otherwise, I apprehend your counsel is upset. I am not very keen either. It is the order of the court which one has to respect. Thanks. Now, thereafter, my lords, the learned arbitrator sends, which is at page number 63, if your lordships will have page 63 for a minute. The learned arbitrator sends that particular 12.5, and please see, my lords, this is addressed to the Honorable High Court, which is at page, we can see at page 64. Page 63 is what he says. Now, he says that as far as discernible from the cause title, I don't think I am anyway related to any of the parties, either in connection with the dispute between them, or financially or professionally, or in connection with any business of any of the parties to the dispute. I only stop here for a minute, my lords. My learned friend will pass on an order. Justice Gupta had been appointed as an arbitrator to adjudicate disputes of Rajahat IT Park in some other matter, which is in complete against the provisions of 12 Schedule 5, point number 24, my lords. A disclosure had to be completely given. Now, why that raises an issue of certain amount of bias in the petitioner's mind is, my lords, now if I can take your lordships to the order dated 14th of May 24, which is at page number 36. It's 11/5/26. Page 36 for a minute. Now, this is the second sitting, my lords, where we appear. Now, please, I may just want to take your lordships to this. Shiv Shankar Banerjee, learned counsel for the respondent, submitted that the previous arbitrator illegally refused to allow the respondent to file its defense. He added that the law does not permit a litigant to challenge an illegal order except under 34. An application under 34 can be filed only after an award has been passed. He submitted in circumstances his client had no order but to commence cross-examination of the witness examined on behalf of the complainant. He submitted that the defendant has an indefeasible right to defend himself both on fact and law. An order passed by a tribunal restricting such right except on the basis of specific statutory provision is bad and illegal. And then he makes a submission. Well, then I make my submissions to the Honorable Tribunal. And I informed the Honorable Tribunal that the similar request had been denied by this tribunal on 14/5/24. And so this was the second bite at the apple. According to him, the seal of finality was also impressed upon the order of the tribunal by dated 14/5/24, passed by the Honorable Justice Ravi Kishan Kapoor in case number so-and-so. He added that just because the of the tribunal has been changed, the tribunal cannot put back the clock. Per tribunal, Mr. Behl, can you show any provision which provides such submission? And I respond accordingly to my understanding, my lords. Then the learned tribunal asked me, did the High Court order referred by you uphold the order of the tribunal refusing liberty to file its defense? And then I give a positive response. I am not impressed by any of the submissions, including the answers to this, according to my understanding and the principles permeated. And then, my lords, what he does is, by no stretch of imagination are intended by the legislature to restrict the jurisdiction of the arbitrator by doing a complete justice between the parties. Settled position of law is that the CPC in that orders which are not appealable under the court can be appealed, and as if the occasion arises to prefer and appeal against the decree, speedy justice was sought to be achieved by restricted the jurisdiction of courts from interfering with the orders. At this stage, Mr. Behel wanted to make further submission. Judgment of the tribunal is not a pleading which can be denied, disputed. The continuous started dictating the order, and then Milodzi makes some remarks qua me. Both parties have failed to comply with the order directing to deposit the initial fee of the tribunal. Parties are given last chance to make such deposit. Once that is done, the judgment shall be delivered and next date of arbitration shall be fixed. If they do not fail, the judgment shall be delivered, nor the next date shall be given to be fixed. Now, my lords, what has happened is that the right of the defendant respondent had been closed by the erstwhile arbitrator as early as, my lords, in 2024. They file a section 14 and 15, and if your lordships will have page 34 of this petition, my lords.
Page
34 minutes.
24.
3-4 minutes.
Yes.
An extra. Now, this was a petition filed by them, and please see, I may just read it for your lordship's kind consideration. Application under 14 and 15, briefly, the parties are contesting proceeding before the arbitrator. The dispute within parties arises out of agreement. The primary grievance of the petitioner, which is Raja Hart, respondent herein, is directed against the fact that the learned arbitrator has not only refused to take the statement of defense of the petitioner on record, but has inter alia held as sitting held on so and so that the petitioner is only entitled to cross-examine the legal issues and not on facts. There are certain allegations on the conduct of the arbitrator which is not pressed. On behalf of the respondent, it is fairly submitted to cross-examine the witness, not only limited to question of law, but also on facts. In view of the submissions on where there is no scope of any interference at this stage, and then the court says that he shall be entitled to raise anything under section 34. So therefore, my lords, once I raise an issue, his right having been closed of statement of defense, he cross-examines and examines and asks about 90 questions to the petitioner, and the matter is fixed for final hearing. At that stage, the erstwhile learned arbitrator says that I am not feeling well, and then he recluses himself. And then we get into this litigation where the reappointment is to be done. Under 15(2), the reappointment is done by this honorable court. And thereafter, my lords, what I'm saddled with is putting the clock back where it all started from. Because that's what the learned arbitrator is now intends to do, start from the written statement stage, when the proceedings at the cross-examination stage is over. So it's nothing but a second bite at the apple. The learned arbitrator says in his email that you are angry with me. I am also not interested, but I am following the court orders. Because in such circumstances, the humble submission is maybe appoint somebody else, my lords, because and the non-disclosure of 12(5), my lords, it was not a complete disclosure. My learned friend who's present in the court can hand over the copy of another order, which was passed where the respondent herein is also a party there, and the arbitrator is the same Justice Gupta, my lords. I don't want any insinuations, but that's a disclosure which had to come, my lords. The disclosure was very important for us. And please see how it is going.
A lot has been said on behalf of the petitioners. My lord, if the learned arbitrator who was appointed now, my lord, kindly sees the date when the order was passed, the order which my learned senior friend is trying to complain against. 11th of May was the second sitting of the arbitral tribunal. My lord, before that, there was no speck of a letter, no scrap of paper asking the learned arbitrator whether you have made a disclosure or not. It is only when they were shunned on 11th of May, 12th of May, a mail comes that you have not filed a disclosure, kindly do this, kindly do that. Now, my lord, after this order, we have already complied with the order of the learned tribunal. Now, what my learned friend speaks of the earlier arbitrator, my lord, before the earlier arbitrator, my lord can find the order, my lord, on page, my lord, the order starts, my lord, on page 47, my lord. My lord, our right, the respondent's right to file the statement of defense was closed because we did not comply with the tribunal's direction to make an ad hoc deposit of 1 lakh in each of the 4 matters which were pending before that learned arbitrator. Now, my lord, after the right was closed, my lord, we had made an application. We had filed the statement of defense. On that basis, my lord, an order was passed that you comply with this, then you come, I will allow you to cross-examine. We have complied. My lord, the statement of defense is already on record. 20th of December, we have filed the statement of defense through the mails. Those orders, my lord, are not annexed to the writ petition. My lord, I think these orders need to come before your lordship to ascertain the correct situation, my lord. May I be permitted to file my affidavit dealing with their averments, allegations, and also bringing on those documents
First, you
which
get the
have not
copy.
come.
Supply him the
I'll
copy.
supply. I'll supply. In my instruction, it has been supplied. I'll again give a copy, my lord. Since my lord, they said some pages are missing, I'll again give a copy of the entire set that I have.
A soft copy would also be fine.
I will then yet I'll give him. I have the soft copy with me.
We'll see it on Monday.
Grateful.
Give a copy in the meantime.
That's on Monday.
Yes.
I'm so deeply honored. Thank you for accommodating me on.
These are 2 matters, right?
Yes, same point.
Yes, please. Same point. In fact, in item 38, the order which I just read has not even been
Two
passed.
different arbitration proceedings, right?
Two different arbitration. In fact, my lords, in item 38, the order which I just read for your lordship's consideration of 11th May, that has not been even passed in item 38. It's just been kept.
We'll see it.
I'm so deeply honored. Thank you for accommodating me on a VC minutes.
Next.
Revision section 36, item 40.
Lord, I am for the petition.
It's depositing the money.
My lord, in this matter, my lord, after the award was passed, thereafter, my lord, they took out an application for execution before the executing court at commercial court at Asansol. We challenged that on the point of maintainability, and being, my lord, that was being disallowed, we filed a civil revision application. In the civil revision application, we have deposited the amount. But that has not yet been disclosed in this proceeding, my lord. Though the deposits, I may be granted, my lord, opportunity to file a supplementary affidavit by which we can.
You have the supplementary.
But I do not have it, my lord. I have the
Valid
documents.
counsel for the petitioner seeks and is granted liberty to file a supplementary affidavit bringing on record the deposits he had made
My lord.
in terms of the award dated.
My lords, 20th March 2020. But my lords, I have the order of the
Award dated
20th March 2020.
20th March 2020. Yes.
My lords, I have an order of the learned commercial court recording that they have paid the amounts. If that can be taken on record, that would suffice the need to.
You'll file all that with the supplementary affidavit. You file this also. Put this on record.
My lord.
Seeks and is granted 2 weeks time to file a supplementary affidavit bringing on record
order the link.
Payment as well as other documents. List after 3 weeks.
My lord.
2 weeks.
No, 3 weeks, my lord.
3 weeks. List after 4 weeks. Okay.
On item 41, my lord, it's the section 36(2) application.
All right. So 40 is your, this goes in 40, right?
40 is section 34 and 41 is section 36(2).
So
Both were taken up
this
together.
supplementary affidavit you're filing in 40.
Lord, if both, I can.
In both you'll file it.
My lord, my lord.
Same order kar dena dono mein. Supplementary affidavit. Supplementary affidavit in both the matters, huh?
Actually, it should be in 41.
It should be in 41.
My lord.
34 I mean 34 is 34.
As your lordship pleases.
So ये 41 में रहने दो ये order. ठीक है 41 में. 40 just tag along with 41. This one.
40 में कौन order बच्चे?
After 4 weeks. They'll give a date.
My lord.
28.
Award is of which year? 20?
Award is of 2020. Thereafter 2 years, my lord, of COVID period, and we had filed in 2020.
नहीं, tag along. List along with AP. उसमें कर देना. For the list along with AP 203 of 2020. 42. Yes, 42.
42 and 43, my lord, I appear for the petitioners in this application, my lord. I am led by Mr. Amit Dubey, appearing from Delhi. He is not present right now, but I can continue with the matter. If
You have deposited the money.
I want to withdraw the amount, my lord.
Application is there.
Application is there, my lord.
On behalf of the respondent, your lordship, we were being directed to file the opposition. I'm filing it. Lordship, in this matter,
Opposition to the application.
I have not been served with a copy of the application, my lord. My lord had granted 1 week time to for them.
Lordship, I'm being
Want to
led.
file your reply to this?
My lord, what is there to file a reply? I have not.
Asking, I don't know. You.
My lord, then I will go through it and file it in 1 week's time. My lord, I want to secure the amount by way of bank.
Proceedings have to be completed, isn't it?
Yes, ma'am.
Affidavit in opposition to GA Form 1 of 2026 is taken on record. A copy of the same has been handed over to the Learned Counsel for the award holder. You're the award holder.
I am the award holder, my lord.
Award holder.
And the petitioner in GA.
Full stop. He seeks and is granted liberty. He seeks and is granted 2 weeks, 1 week.
1 week, my lord. 1 week.
Take time to file his reply to the affidavit in opposition.
This is item number 42, my lord. This was item number 42.
List after 2 weeks.
Yes,
So this goes in item
this was item number 42.
42. What is 43?
43? 43 is, my lord, my application for withdrawal of the amount. Again, two different awards.
We'll keep it up with this list
Uh,
along with.
My lord, in that matter,
Reply
we have not been served.
Wait a minute. So reply is in 43?
Reply is in item number 42 or 43? 42, my lord.
42. But your application for withdrawal is in 43?
Both of them. Two different
Oh,
awards.
two different awards.
Yes, ma'am.
What about the reply in 43?
Opposition, my lord.
Opposition.
Lordship, 43, I'm praying for short passover. My senior is
Where's the
engaged in.
reply? Passover, I understand. Where's the reply?
Sir, I'm called for the brief on the yes, sir. Lordship.
What are you
short passover.
Have they filed a reply, sir?
No, my lord. They have not filed an opposition.
They had taken time to file opposition?
Yes, my lord. 2 weeks, my lord. If my lord takes up the order.
Who's the counsel?
Madhu Jana.
Where is she?
She is engaged in court at 32, Lordship. Lordship, please
What the
kind
order?
of short passover.
You are there in this matter?
Yes, Lordship. Yes, opposition is.
Reply is there? Give the reply.
Opposition.
Opposition. Affidavit of opposition filed by the award data is taken on record in GA. This also must be GA? GA
GACOM 1.
Of 2026 is taken on record.
90.
বুঝতেই পারছি না কি হচ্ছে দুটোই এক কি করে হবে
Give a copy.
not received a copy
960. It need to correct.
960.
Yes, we're 960.
Give a copy to him. Copy of the
no copy
of the same has been handed over to the Learned Counsel for the award holder / petitioner. He seeks and is same.
if my lord grants me one liberty, my lord,
after 2 weeks.
In the orders passed by your lordship, my lord, it has been wrongly recorded that the award was of 14th March 2025. It will be 2024 in both the orders on the last occasion, my lord.
Award dated?
Award dated 14th March 2024, my lord.
It is recorded 18th April.
No, it is recorded 14th March 2025 in the order.
No, it's 18th April 2024.
In 18th April, that is one, my lord. That is in item number 42. In item number 43, my lord.
Wrongly recorded.
Yes, ma'am.
That is This is ये वाला कौन सा है ये नहीं 910 है 960 ये 43 इसमें 43 में चेंज करो 42 an inadvertent error crept into the order dated 17 July 2026 wherein the date of the award has been wrongly noted as 14th March 2025 instead of
14 March 2024.
Instead of 14th March 2024.
Yes, ma'am.
ठीक है The rest of the order will read as it is.
Grateful, ma'am. আগের বার নামগুলো ভুল চলে গেছে দেখে নিও আগের বার নামও ভুল চলে গেছে তোদের নামটা কি
Grateful. Now 44.
I appear for the respondent. This is a section 36 application.
I'm appearing on behalf of the petitioner. Learned Counsel Siddhartha Lairi sir is appearing in this matter, leading us. Lordship, kindly grant me not today. She has legs over different court arguing since the morning, Your Lordship.
Has it deposited the money deposit?
No, my lord. They had undertaken, my lord, in the execution there was an order.
Not today, then we'll have it on
July's order.
Monday. We'll have it.
Monday is fine.
Delhi Metro. Where will they run away?
Kolkata Metro. Kolkata Metro and BCL.
Kolkata, whatever Metro. 36 application, right?
This is the 36. Item 40, item 48 and 49 are the section 34s.
Lordship, in item 48 and 49, I'm filing the affidavit in opposition, Your Lordship.
48, 49.
48 and
Wait a minute. So 45.
44, my lord. 44 is there, 36 2.
Which they have not deposited the money. What is this?
This is 48 and 49, Your Lordship. They have asked for the opposition.
Just a minute.
Not asked for an opposition. They are filing the opposition.
Yes, Your Lordship.
48 is, I believe, their section 34. In my section.
34, just take down. Proxy counsel so and so appears and states that the main arguing counsel in some personal difficulty prays for an adjournment. Let this matter be listed on Friday. Next Friday. Okay. 44 next Friday. And
44. This is, I believe,
just a
their
minute.
opposition.
Just a minute. Let me call all the matters. Wait. 44 is done next Friday. Call 45.
45.
45 hour application, my lord.
Yes.
The setting is set up the award and will stay, my lord. Well, earlier, my lord.
36 application, right?
Lordship, there's the 36 and the 34. My lord was inclined to hear both together, my lord, because they are really alleging that there is ground for unconditional stay. On account of fraud.
Wait a minute. इसको वो जो hearing वाले रखे ना just give the numbers. We are picking 2 days for hearing 34 petitions.
Lordship.
So we'll keep this in that.
Lordship.
All right. Just give the details.
Yes, my lord. Just
My lord, my lord.
Simply not today.
My lord. Grateful.
Both 45, 46, simply
My
not.
lord, both.
And now 47. And then new motion section 34.
47 also, Siddhartha.
Not today, not today.
No.
Yeah.
48.
48, I believe, is their section 34 application. And in 49, my lord, I have an application for amendment of the section 34. Very minor technical formal change. We are partially challenging the award. The word partial doesn't appear in the prayer finally. That is my limited. Entire pleading, my lord, is on partial setting aside of the award.
This is
item 49.
This is also let it be on Friday.
My lord, Friday, my lord, I'm led by Mr. Chayan Gupta. He's specifically asked if
So nothing much is going to happen that day.
Very well, my lord. The amendment, your lordship, is
Lordship,
keeping.
I'm filing the affidavit in opposition.
Don't file it, not today, Friday.
44 44.
All right. Rest of the matters.
Okay.